Mhm.
Hi, everyone. Ian Aldridge here from Progressive Legal. I've got Jacob and Riet here today who are going to help us break down the 10 common trademark myths and misconceptions. The background to this webinar is we find so often people commenting on social media or word of mouth when people are talking about trademarks, their own experiences and what they think about trademarks or what they've heard, seen, or heard other people talking about trademarks. And we've just found there's a lot of misconceptions and myths that surround trademarks in Australia. One person's opinion gets cycled through to many others. So we're here to basically do a MythBusters episode on trademarks, and also just go through some practical things about trademarks that we've learnt in our experiences and helping 4,000 businesses in Australia with their intellectual property protection and commercial, etc. And we're also seeing trademarks just becoming generally more important for businesses as they wise up to how powerful a registered trademark can be to either stop others from trying to come in to the market and confuse and take customers away from them, as well as using it as prosecution to stop them from coming on like a shield, and also a sword as well to stop others from coming along and trading out there in the market. So a two-pronged approach to the power of the registered trademark. All right, Riet, Jacob, take it away.
All right. Well, Jacob, let's start on the first myth. Thanks for the introduction, Ian. So for most of our clients, trademarks are such an important aspect of their business, and it's something that comes up in the daily life for everyone, but especially for every business owner. So there are a few common things that we're seeing with a lot of our contact within the field of IP that are just worth discussing in a CPD to make sure that everyone knows how to deal with these common misconceptions. Now, the one that we're seeing the most is myth number one here. Thinking that registering a business name or company name or trading name, for that matter, is the same as registering a trademark. So there's a lot of differences between the two, but the common misconception is that because you've registered your business name, you have the right to the business name, and from that point on, you are protected from anyone else using or misusing that name. Well, the first part that we really feel like it's worth highlighting here is that registering a business name, it's just an administrative process. It doesn't serve as much more than registering where you live or your email. It's a way to show people where they can find you as a business, under what name, but it doesn't actually grant you any exclusivity to that name or a monopoly to the use of that name. So the only thing that can do that is registering a trademark. IP Australia doesn't check for any business name registrations or company name registrations either during the process of getting your trademark application filed and examined and then registered. ASIC doesn't do this either. So when you register your business name or your company name on ASIC, all ASIC would do, and correct me if I'm wrong here, but from my understanding, all that ASIC does is to check for any identical names that are on the register. So if there are identical names, you might get a notification from ASIC saying, well, this name is not available, similar to registering a domain name. But they won't check if there's any business names, trademarks, anything in place that would have the potential of being really confusing to coexist with. So by registering a business name, if you get that through, you have the right to use that business name to identify yourself as a business, but you don't actually have the right to use it as a trademark. And by doing that, if you intend to use that business name as your trademark, it's still really important to go through the trademark application processes at IP Australia. Now, the real difference lies in the way that application will be examined by IP Australia. So it doesn't just check for any identical trademarks that are already on the register, but IP Australia also checks for any trademarks that are substantially identical or deceptively similar. Now, that's quite a broad scope of search that IP Australia does. And it also means that once you have that registered trademark, you get a really broad scope of protection, because any trademark that would be substantially identical or deceptively similar to your trademark, that relates to the same or similar goods or services, would be held back by your trademark. And once your trademark is registered, you get the right to enforce it.
It's interesting, isn't it? Because both IP Australia and ASIC / Australian Business Register don't check each other. So, and when you go through the registration of the business name through ASIC, it actually says there if you read the fine print, well, it's not really fine, but it's a bit smaller than the rest. It does say this, registering this business name does not grant you exclusive rights, to this. In order to do that, you need to obtain a registered trademark. So along those lines. So it actually does tell you, we all don't read this fine print, of course, when we're registering the business names. But it actually does say there, this doesn't give you exclusive rights to it. So that even ASIC realizes that this is a common misconception in the market, that, oh, well, I've got the business name, that means no one can take that, no one can take that business name and use it in the market. Well, actually, no, that's not the case. And there's been countless instances where vice versa, if say, for instance, the people have come up with a particular business name or a derivative, like a product name or something, what they thought was new and unique and novel, have come up with that for the purposes of branding, and then done the search on the Australian Business Register, found out, the business name's not registered, company's name not registered, then we're fine. Only to find that later, when they've come to us for advice about registering a trademark, we've picked up that there's potentially 3 or 4 similar or identical marks on the register over those goods and services, which would probably prevent them from trading. They've had to go back to the drawing board. So it's really vital to check both, obviously, before you go and start trading. And when you're registering a business name, through ASIC, if you've got they won't let you register a business name now if it's identical to a current business name or a company. So even if a corporation has that exact name, apart from the proprietary limited, and it might be a trust, it might be a corporate trustee that doesn't trade, or it might be a holding company, something else that's not potentially trading, or a self-managed super fund, whatever it might be. There can be differences between the ASIC register and the Australian Business Register, and that's why we want to check both before we're looking at potential trademarks as well, just to make sure that there's nothing else out there that's currently registered. Because you wouldn't be able to register a business name that's exactly the same as the proprietary limited, and unfortunately, that's regardless of whether or not they're trading. So it's that, and so, as Riet was saying, they're really just an administrative body that facilitates the registration of these names, just like IP Australia is a administrative body as well, that facilitates the registration of trademarks in Australia, but doesn't look any further than any direct conflicts over those goods and service classes for that name, or same or similar, that may be mislead, may confuse the market. They're really operating in a vacuum. They don't go broader and look at business names or what's in the market either. So but we often hear this, we often see this on social media, on Facebook groups, where people say, "Oh, no, you don't need it. You don't. I was told you don't need a trademark because if you've got the business name, then you've got you've got the rights." And it's just one of those things that we have to constantly chime in and say, "No, that's not the case. Please, stop spreading this misinformation because it's not true." And only a full registered trademark allows you to to get what gives you the highest and best rights to stop others from trading, so long as obviously you registered in good faith. There's no one else out there. You were there first. We've got a first to use system in Australia, not first to register. Although obviously registration certainly does help.
I think the other thing to consider there too is that the business names, they don't take into consideration like the specific goods and services that are going to be provided. At the end of the day, from a policy perspective, it's not great to have an individual having a monopoly over a particular name in relation to all goods and services. We would have run out of names long ago if that was the case. So trademarks are really the only way you can get that sort of exclusivity.
Yeah. Plus, it's part of the due diligence when you start a company as well, to check whether your business name might be used as a trademark already. So it's important to at least check the register right away when you're thinking about adopting a new brand. Which might bring us to myth number 2 here, because another general misconception that we do see a lot is that there's just no need to register a trademark regardless of the value that a business name might hold. Ian just touched base on this a little bit, but there are some really important differences between a registered trademark or not having a registered trademark. You can get some kind of rights that you build up through using the trademark for a long time in a marketplace and building up a reputation within that marketplace for being the trader that uses that brand. So if you have been using your trademark for, let's say, 10 years, and when people hear that trademark, they automatically think about you and your product or your service and your business, then that does count for something. It gives you, of course, you've built up the goodwill, and it gives you the common law rights to that trademark. It's not as clear cut as having a registered trademark, because you'll need to prove that that reputation that you've built up in the marketplace is substantial enough to be able to claim those rights. And that can be a bit of a difficult thing. But some other important differences between common law rights and registered trademark rights are that pending and registered trademark rights can be raised as an objection against any new trademark applications that are being filed. So in that sense, any trademark application or registration on the Australian Trademarks Register is already acting as a barrier to any new traders that are considering or perhaps just started trading under a new name. Because once they file the trademark application, which fingers crossed they do at the beginning of their process, they will see that there is already another trader using that might be your trademark, that's already using or has already claimed the rights to that trademark. And that might be a real issue that you can consider before you adopt that brand. This is why it's so important as well to look into filing a trademark application at the beginning, so you are aware of any potential issues that there are with pending or registered trademarks that are already out there. Now, the great thing about the application system with IP Australia is that they have that opportunity to raise any existing trademarks against yours. Without having that application or registration in place, there might be a similarity between that trademark application and the trademark that you've been using for 10 years. But IP Australia won't pick up on that, because all IP Australia will search for while examining a trademark application is the register. So they will look on the register and they will do some searches online, but just to see if a trademark is commonly used more than used by a particular trader. If they don't see any similarity between the trademark that has been applied for and a pending or registered trademark on the register, your trademark will not be able to hold that trademark back from being approved and registered down the track. You would have to rely on the trademark application process, which happens before a trademark is registered and after it's accepted, or you would have to try to get that registered trademark removed if it has proceeded to registered status without you knowing. Now, the only way to resolve that kind of problem would be through court action, which comes at a high cost, and whether or not that's worth it, I mean, yeah, it depends on the value that your brand holds at that time, but it's a nasty process that can easily be avoided if you have your trademarks in place. So that way IP Australia can take that effort of holding back any new trademark applications and registrations for you. So the enforcement of your rights would be much easier then, because a part of the problem having any new trademark applications coming in is already being resolved by IP Australia, because they will effectively hold all those back from becoming a registered trademark, with some exceptions, but we can discuss it in a different CPD.
Yeah,
yeah.
I guess the real thrust of it from the takeaway is if you don't have a registered trademark, if someone comes along and starts to trade and confuse the market, the difficulty that you find yourself in from a practical perspective is, and clients come to us, with this all the time, is that if they haven't taken those steps to register the trademark first of all, you've got an issue that it takes 8 months, 6, 7, 8 months, depending on, IP Australia, and also whether you do a fast, speed up the process of the examination, etc., to get the trademark registered. So what happens is you're trying to speed up this process of trying to get your trademark registered. In the meantime, the enemy is already confusing the market. You've got at the very least 6 months, 7 months, 8 months until you get a trademark registered, unless it's opposed. Also, too, if you've got someone else that's tried to come onto the register, that particular entity has tried to register the trademark effectively underneath your common law rights, which you've been accumulating all this time, then you will then need to necessarily oppose that trademark application if it is accepted by IP Australia within that 2-month window, which is obviously a very costly exercise. The business is under an immediate external threat to its livelihood, because another organisation or person is out there effectively taking business away from the organisation, confusing customers, diluting your brand. It's extreme, for our clients, we know this and we can talk about it generally. It's extremely frustrating. It's very disruptive to the organization. It's very costly, stressful, time consuming, that having to fight this external unnecessary threat instead of being able to concentrate on your own business and building the business and income producing activities. And getting on with the day-to-day of your business. And it takes up a lot of headspace. And this is why trademarks are just so amazing. And the more we're sort of dealing with trademarks, the more we see what the true power really is, that if you've already got the trademark, at the very least underway, and you've got a filing date, first of all, it stops others from coming on underneath you, because if you've got a filing date first, anyone that tries to register after that date, yours will come up as a cited mark against theirs. So that prevents them from getting registered if you've got overlapping services. But the other thing to consider as well too is that we don't know how many near misses there are, and a lot of businesses, and there's this commercial warfare out there in the market. They'll have a look and see on the register and see whether someone's registered a trademark for it. And if you haven't registered your trademark, they think that it's fair game. And so they can start trading the market, start accumulating their own common law rights, even though yours will probably trump them, if it came time for a battle because you were there first and using it in the market. The point is, you just don't want to go there, because then you're having to fight someone over common law rights, where if you are to take it to court, then you have to prove reputation in the market. And that's the real challenge. You don't need to prove reputation if you're under the Trademarks Act. And so that's what really is the power of a registered trademark. Sure, when you're taking legal proceedings against another, against an enemy that if you do have, it doesn't stop someone from going along and trading. It just means that you have more powerful rights when it comes time to enforcement. And the amount of people that don't register a trademark because they don't try and trade in a market because they can see, oh, they've got a registered trademark, when we're just not going to bother going there. So we don't even, it's kind of like having really good legal documents. You don't know how many times you don't get into legal troubles by having the legal documents, because you wouldn't know. We know because we have people coming to us for advice saying, hey, can you give us some advice about this contract, and what are our rights here? And obviously the conversation differs greatly when there's really great legal documents, really well drafted, and ticking all the boxes from a legal perspective, and the clauses that they're looking to enforce are really well drafted. That conversation is very different if say, for instance, the contract isn't like that. Similarly with trademarks, when a client comes to us and says, oh, I've got a cease and desist letter for trademark infringement, and we can see that the opposition has registered trademarks, obviously very keen on protecting their brand. They were there first. It's just the conversation is, it's very different if that's the case, because we understand how powerful the registered trademarks are. And when you come before a court, it's a lot, more of a straightforward process, where if you have registered trademarks, where the court just looks at, oh, well, here's the registered trademark. There's a clear infringement there. You don't need to prove reputation, so that means that all the evidence that you would normally need to gather in terms of your use of the mark in the market over a period of time, for those goods and services that you're claiming are being infringed, that just doesn't need to happen, which is obviously very costly to amass all that evidence, and it's doubtful whether you're going to be able to prove your reputation in the market, and that this other person and this other entities should be stopped from trading and confused in the market because you were there first and you've amassed all this reputation, and reputation needs to be quite significant. It's not the easiest bar to jump. So there's that a little bit of a unsureness whether you're going to be able to win this trademark battle, even though you haven't got, if you haven't got the registered trademark. So it just increases your chances of being able to prosecute trademarks if you've got the registered trademark. And that's really what it's all about.
The other thing to consider there too is that it's also about, security in your own use of your trademark. Particularly if you're a startup and you don't have the use to sort of back up, your rights, you at least have something there to say that you have a right to be able to use that trademark in relation to the goods and services, as long as you're, using the trademark and keeping everything, valid. You at least have that security that someone's not going to turn around and tell you that you can't use that trademark. Yeah.
Exactly.
And technically it's true. You don't need to there's no legal obligation for you to register a trademark, but all the smart businesses register their trademarks because they know how important it is. If you're trying to get investment in your business, you'll see it on Shark Tank and Dragon's Den and all the other investment shows. They'll ask, like, where are your trademarks? And obviously in the market with investors, if you're looking to get investment in the business, that's one of the tick boxes that they look at, because they know how disruptive and costly and almost business ending some of these trademark disputes can be. Obviously at the higher end. If somebody else is out there, so they'll literally say, before we open our wallet, go and register the trademarks. At the very least, get clear reports. Make sure there's no adverse reports, and that you can that you can register it with IP Australia, and IP Australia says yes, and also too that no one else is out there using the mark and is going to oppose it. By which time, as you understand, with that 6, 7, 8 months, the time might pass and they've gone and invested their money elsewhere. So like there's no legal need to register a trademark. There's no mandatory, it's not mandatory for you to do it. So in a way, that is true, but it's just obviously all the big businesses do it because they're smart. But also the smaller businesses are starting to realize how powerful it is, and also being able to fight off larger businesses with a registered trademark has been very useful for our clients in the past. Obviously, I can't talk about them due to confidentiality, but we've been able to fight off a number of large opposition, international, global, international businesses, just purely by having registered trademark or registered trademarks for our clients in Australia. And traditionally a lot of US companies come to Australia, think they own the world, and we'll start to bully lots of smaller Australian businesses, saying, "Oh, we're big, you're small." And the
Burger King Matters famous for that.
Yeah, and the complete difference between that make or break with those cases has been the fact that they've had registered trademarks and had registered trademarks for quite some time as well. And obviously the common law rights is your rights that you amass as you trade and build a brand and reputation in the market without having the registered rights. So I think that's the real myth here. It's like, oh, well, I've got my common law rights. That's enough, and it's proven time and time again that one, it's not, because if you've got an opposition against you with extremely deep pockets, if you don't have a registered trademark, there's that commercial warfare happens all the time, and you just never know when a large organization thinks, "Oh, that's a great idea. That's a great name for that type of business," and they release a product line, a service area. It could be completely out of the blue, and the business goes in a new direction, and suddenly thinks that's a really good name that's a really good name for a product. That's a really good name for a service. Who's using it in Australia? Oh, just some small business, but they don't have a trademark. Okay, fine. Well, let's register the trademark, and we'll steamroll them. Like that's the conversations that are happening in some of these businesses. But obviously, it's very different if you've got the power of the Trademarks Act behind you. It's a very big, powerful act that gives an enormous amount of rights, which is really advantageous when it comes to court, and that's what it's all about. It's all about when it comes time to enforcement, you want to have the greatest rights, you want to have the most as possible, and bang for buck. It's a very inexpensive way of gaining those registered rights, which are renewed every 10 years. It's not like you have to, like with business names, we renew them every year or 3 years, or domains, which you have to renew every year. It's 10 years. Like once you've paid the fees for them to IP Australia, then that's it. That's all. That's as long as you keep using it and nobody else files an opposition against you, or files an application against you to remove it, it's yours for 10 years. So from a cost perspective, it's a no-brainer.
Well, and
these two
sorry.
myths are really important because they're the main ones that make a really big difference to whether people basically can keep their brand or keep their product names or service names.
Yeah. And I think the third one is one that I uh, see a lot and find pretty concerning at times as well. There's just a lot of people think that a trademark registration in Australia grants you protection globally. So having registered your trademark somewhere means that no one in the world can use that trademark anymore to promote or sell similar goods and services, which is unfortunately not true. Like Jacob mentioned earlier, the bucket of potential names would run out so quickly if the entire world would have to succumb to a trademark that's only being used at one place. So there are local rights and regulations that trademarks are subject to. And because of that, you need to register your trademark in each jurisdiction separately. So it's not necessarily on a country to country basis because there are agreements like the EU. There are several agreements in Africa that allow you to file to register your trademark in multiple countries. But yeah, you have to register your trademark per jurisdiction. Because of that, your rights are limited to only that jurisdiction that you have filed your trademark and register your trademark successfully into. There are ways to file your international application a bit more easy though. The World Intellectual Property Office, WIPO, has a Madrid protocol, and that allows you to file an international trademark application in several jurisdictions at once. So you can file the one international trademark application, WIPO will register that, and then it will designate all the countries that you've ticked up the boxes from when you filed your application. So that way you can file that one application into 20, 30, 50 jurisdictions at once. But once it's filed and once it's registered as an international trademark, it still needs to be examined and it still needs to be successfully registered in each jurisdiction separately. So it still has to pass that examination and pass the local laws and regulations. It has to not be too similar to any trademarks that already exist in that jurisdiction. It can't be too commonly used in that jurisdiction. So there's a lot of things that needs to be checked, a lot of boxes that need to be checked on a local basis before your trademark is registered. So there's no worldwide protection per se. It's without a bit of effort.
and each of those different jurisdictions have peculiarities to them. It's not the same everywhere in the world. We wish it was, but it's not. And because the state of those trademark registers differ with different countries and different zones, because obviously different businesses there's, say for instance in the US is a good example, there's significantly more business obviously in the US, so as you can appreciate, it's a little bit more challenging as a general statement to get onto the US register because there are a significant amount of businesses trading in the US as opposed to say Australia. So generally speaking, it's but obviously it's case by case basis, and it depends on your particular brand name or product or service that you're wanting to register as a trademark, and obviously what's out there in the market already and on the register. So that's why it usually requires a local agent within each of these jurisdictions, which we have those representatives that we've established relationships with. And what we recommend is engaging us to at least have get that quick advice first to see whether there's any direct conflicts on those registers, and get their general high level prospect of success. What do they think for that particular jurisdiction before filing, and obviously we've saved clients plenty of money by not filing trademarks where they would have had either no hope or engage or almost certainly had litigation proceedings brought against them as the US, I keep mentioning, but being very litigious as a country, so opening up, to attack is not a good idea if there's a direct conflict for potentially a business that is well known for prosecution of those trademarks. So it's not, it's certainly not advisable just to register your trademark in a whole bunch of countries. Especially in circumstances where there may be rules too that, like for instance, the US I mentioned again, you've got to sign off on a declaration before you even file there to say that you're either trading or imminently, about to trade in that country in order to file the trademark to begin with. And each of the different jurisdictions have different rules. So we sometimes use WIPO's Madrid Protocol when it makes sense from a financial perspective to do so on behalf of clients, but it's a real case-by-case basis, and sometimes we decide to use local agents to provide that advice first, because sometimes as well it makes sense to have that person engaged in that jurisdiction right from the get-go, so that, and if you know that it's probably likely that we'll get an adverse report, so we're going to need to get a local agent to advise anyway, so it's best to get them earlier in the process rather than later. And you can imagine, if you want, a lot of clients come to us, I want to register in every country, in the world, because I'm going global. But they quickly realize that it's an extremely expensive process if you want to register in lots and lots of different jurisdictions. So our general advice is, let's work it out in order of priority. What are those markets, one, that you're currently in, or two, that pose the greatest opportunity that you're looking to get into sooner rather than later, and do them first cab off the rank, step by step, one by one.
Exactly.
The other thing that's important to remember too, Riet, can you expand on this a bit in terms of getting the registered protection, the filing date and the window to then register internationally?
Yeah. So there's quite a few international regulations that IP Australia, New Zealand, and lots of countries are part of, which is all under the Madrid Protocol as well, related to it. Once you file your trademark application in your local country, so for us, Australia, you have 6 months to think about your international options and arrange for that international trademark application to be filed. So within those 6 months, you can file your international application and still claim the priority date that you were originally given in your local country. So that helps you to maybe see how your trademark goes through the Australian examination process first, and then decide if you wanted to move that forward and take that internationally, or it can help just move some costs, give you the chance to get ready for the fees that come with international trademarks, especially if you do need to file in quite a few countries. So you get a bit of a chance to spread risks and costs by filing in that 6-month priority window that exists for any trademarks to be filed internationally. And because you can still claim the priority date from Australia, yeah, your rights still kick in on the same date once it's registered.
And it gives you time to organize yourself too, to then, try, be able to, so say for instance, I've got this product in Australia, I want to launch it in the US. Well, okay, if you want to launch in the US, that's great. You got 6 months basically to get your act together, to be able to then, sign off on the declaration, as I said, file the trademark, and claim that earlier priority date. Why is that earlier priority date so important, Riet?
Well, that's the date that ultimately your rights kick in. So once your trademark's registered, it will be registered from that day forward in most countries. Your rights will go back to that date. So anyone that started using your trademark the day after you filed your application in Australia and then moved that trademark overseas, claiming back that same date, can be in trouble because you were essentially first. And some countries follow a first to use system, but there's a lot of countries out there that follow a first to file system. And it means that whoever filed their trademark application first, whoever has that first priority date, that earliest priority date, that is recognized as a true owner of a trademark. Being the first can avoid major issues that we've seen with, unfortunately, quite a few of our clients over the years, just not our clients here, but just in the field, in this line of work, where you might not be the first one to file that trademark application in a country, and you move your manufacturing process to that country. Someone else filed your trademark application before you. You missed that 6-month priority window, so you can't back claim that earlier priority date. You lose your rights there. And it's so difficult to get your rights back if you're entering a new country and you are starting from scratch to build up your use and reputation in that country. So you really want to have the earliest possible priority date to avoid any risks of dealing with these kind of nasty situations. So yeah, it can be really, really valuable.
There's a tension too, right? Because you can't, like if you're already trading in the US and Australia, you really want to get your trademark registered in the US as soon as possible. Like, don't wait until the 6 months comes along and then claim that earlier priority date. Like you want to get on the register as soon as possible in the US too, because one, it'll stop anybody else from coming on the register then and there. But in worst case scenario, if you do wait that 6 months, someone else comes onto the register in the US in the meantime. And remember too, like businesses are watching other businesses that are growing fast nowadays too. So, and it's interesting to see how, someone might come up with an idea here, but at the same time, they come up with the same name or the same idea in the US or Canada or Europe, it's UK, etc. And apply to register that trademark there as well, almost uncannily. And we've had situations where we've had to advise, clients, look, you need to get on the register in the US as soon as possible. Yes, we're not trading there yet. In the meantime, someone registers a trademark there in the US. They are able to register in the US if they claim that earlier priority date and effectively leapfrog the other trademark owner. The problem is the other trademark owner has already started trading in that, whatever, up to 6 months and obtaining their own rights. They're also on the register too. So there's a coexistence on the register if, say, for instance, they had applied earlier, which would have prevented this, the enemy's trademark from actually getting through, then they wouldn't have got a trademark in the first place. So these are the practical considerations when dealing with this stuff, and sometimes it does come down to affordability and when to get that. But don't just rely on the fact that, I can claim it. I've got 6 months to claim it, so therefore I'm going to wait 5 months and a half and then do it then. You still run the risk of somebody else coming on the register in that jurisdiction and getting on there in the meantime, and then having a coexistence issue and then having to negotiate that coexistence or getting into a legal fight. So better not to have the fight at all, just like getting a trademark on the register in Australia. There's this common saying, like, possession's 9/10 of the law. And I think that almost sort of applies a little bit with trademarks, because it's very hard to take a trademark off someone once they've got it. It's and 9 out of 10 times people will just not bother or give up, or it's too costly to get that removed, so they just don't do it and move on.
And that actually brings us to our fourth myth with a nice introduction, Ian, because once you own a trademark, there is one way that you are able to lose it. And one common myth, well, there are maybe more ways, but there's one rule that is written in the Trademarks Act as a law, and it's that you can remove a trademark owned by someone else once after registration due to either bad faith at the time of filing a trademark application, or due to that trademark not having been used on the goods and services that is registered for a period of 3 years. So that has to be a consecutive period, and it starts 1 month from the date that removal application would have been filed. There's a similar process in New Zealand too, and in quite a few other countries overseas. That non-use period would be either 3 or 5 years usually. So the common myth is here that a lot of people think that once you own a trademark, it will be yours forever. And essentially it will, but you do have to use that trademark. So without having some use in good faith in place by the owner, there is actually vulnerability to your trademark. So because of these things, it's so important to get everything right at the beginning as well, because if there's any inconsistencies in your trademark application, but you don't know about them, and your trademark is registered, and then 5 years later, you get a notification from IP Australia that your trademark is being removed from the register because you, as the registered owner, haven't used it because that trademark application might have been registered under your personal name, but the one that is using your trademark is actually your company. So some of these inconsistencies at the beginning can actually really bite you in the back later. And it can cause for your trademark to be potentially removed from the register down the track. So this is one of the things that can be done under law. Any party can apply to remove a trademark from a register for these 2 reasons. Once an application like that has been made, you get a 2-month period to oppose that application as the registered owner. And once you would oppose that application, there are a few avenues that will be available to you. You can show good faith at the time of filing in case bad faith was claimed, or you can provide evidence of use showing that you have been using your trademark in that 3-year period that's relevant on the goods and services listed on the registration by the registered owner, and it has to be the trademark that's displayed on your trademark registration or some minor differences that don't substantially change the trademark. So there are a few things that really need to be clear once you need to oppose a removal application, and you have to make those clear to the hearing officer that will be appointed to the file. Because of those things, it can be a bit more tricky to prove your good use, your good faith use of a trademark. So it's really important to have someone make sure that all those details were right from the start, because then you'll be able, if all the details are right on your trademark application at the time of filing, it's registered, and you've been using it as you went along in good faith. If you would ever receive a remove application like this, then you can tick all those boxes. So you're able to keep that trademark, even if someone tries to challenge it under the Trademarks Act by this section. Also, the chance of someone applying to do that will be really, really unlikely, because obviously if they already can see that you have been using your trademark and it has been used in good faith, there's no point of filing a remove application because there's no chance of winning that. So yeah, there's a few purposes that this rule has, and maybe Jacob can just go over those 2 from your end.
Yeah, so
Yeah.
I mean, the real main purpose is to ensure that the register's up to date, that, you know, the people who have exclusivity deserve exclusivity, that they're actively using the trademark, that there's not these, you know, outdated trademarks that are really clogging up the system and, you know, preventing other people who may genuinely want to be, you know, using these marks, you know, from obtaining rights. You know, that's one reason. I guess the other reason as well is to limit down people's specifications that, you know, maybe they've applied for a trademark that's a bit broader than, you know, what they're actually using. Maybe they had some grand plans to have, you know, quite a broad scope of goods or services, but then, you know, throughout, you know, their time conducting their business, they've, you know, really narrowed down their goods and services that they're providing. And so, you know, it's a matter of making sure that the register accurately reflects what's actually being used out in commerce.
Yeah, exactly. And a big part of the reason why this section is in the Trademarks Act is because IP Australia doesn't do these kind of regulatory checks by itself. So there's no system in place within IP Australia that checks whether registered trademarks are still being used and how they're used, etc. They do leave that part up to everyone else in trade to
if they
deal
oppose
with
them,
any
yeah.
unused trademarks. Exactly. So
Yeah.
it's quite common that we would recommend with one of our clients, for example, to file an application to remove a trademark from the register, even though it might have been sitting there for 20 years and it might have been owned by a really, really big famous company. But if it's not being used anymore, it could just be that it's still there because no one took action. And a lot of big companies just automatically renew any trademarks that come up without checking whether or not they're being used. They just have a regulatory system in place, might be done by their accountants, who knows. But it definitely happens that a trademark is holding another trademark back. And when you look at that, it might be like, oof, I'm going to have to rebrand, or there's something happening here that's wrong. But it's always worth having a professional just check all the details first, because maybe the trademark hasn't been used for 10, 15 years. Maybe it shouldn't be there anymore.
Or the particular goods and services that are claimed under that trademark haven't been used. It might not be the whole of the trademark. I'm conscious of the time, and I know that it's completely my fault because I was gas bagging on and talking till the cows come home. So I know we've got 10 minutes, so we need to keep moving along because we're only at myth 4.
Exactly. All
Sounds
right.
like we needed two CBDs to cover off on these.
I need to. Now, myth 5 is a quick one. So I'll at least run through that within a minute. A trademark can only be word, phrase, or logo is what we get quite a bit from our clients. They're definitely the most common way of trademarking. So, of course, a brand usually would have the words as a main feature. It might have a good tagline or slogan that really is worth protecting, setting that product or service apart. And often companies, businesses use a logo. So words and logos and those phrases are all worth protecting as a trademark, because they all have very separate features that help recognize your business and separate those goods and services from those offered by your competitors. But there's many, many other types of trademarks that can be registered as well. It can be a combination of those things mentioned above. It can have words, logos, and the tagline all in one. We call it a composite. There's certification used by certain companies, but they do come with a few angles and hooks that you need to be aware of. It can be a series. If there's a lot of trademarks that you're using, and they all sort of relate to each other, but they're just a tad different, we can look into getting all those filed into one application. It can also be sound, movement, shape, color, scent. So there's quite a few things. As long as it's used as a badge of origin, as long as it shows people that this brand belongs to your company, your business, it might be able to be registered as a trademark. So there's a lot of things worth exploring and discussing to see if you can protect it as IP, add it to your IP portfolio, increase the value of your business, increase your enforcement abilities, et cetera, et cetera. All right, conscious of the time.
Book titles as well, I see that commonly in the market. Oh, you can't register a book title. Oh, I'm pretty sure, it's capable of registration. So,
especially if
I'd rather have it than not.
Yeah, if it's a series of books, it definitely is registrable as a trademark. So it's one of those things that's definitely worth still having a look at and figuring out whether or not the rights are there.
It's myth 6.
Myth 6. There's no rush to apply for a trademark. Well, I think we've already went over the length of time that it takes to register a trademark, which is at least 7 to 8 months. So there's no rush to apply for a trademark if you don't intend to use it right away. But if you want to start publishing the trademark quite quickly within a year, you really want to get started on that application process as soon as you can, because IP Australia cannot guarantee that a trademark will proceed to registered status until that certificate of registration has been issued. There's a few processes that your trademark has to go through. As mentioned, examination, opposition. There also might be situations where IP Australia would accept your trademark, but then might need to retract that because an international trademark was filed in Australia within that 6-month priority window and is now holding your trademark back, even though at first sight they thought it wasn't. There are all these situations that could happen during your trademark pending process of the trademark application. So it's really, really worth getting that process started as soon as possible, because once you have the certificate of registration, you can have that certainty that you have the enforceable rights, you can claim a monopoly, you can move forward with your brand, all your investments, and you have that right to take action if you need to.
And we often find too that clients will say, once we send them the email to say, oh, your trademark's finally registered, they're like, oh, that was quick, because everyone knows that 7 to 8 months goes really fast in a business. And it's just got to go through that process. But once it's underway, it's underway, and you let it run its natural course, and business as usual in the meantime. It's only a rush to register the trademark when you've got someone else out there in the market trying to confuse the market. That's when there's a rush to apply for a trademark, which is always awful.
The first thing we would say if we have a client that mentions this kind of an issue happening is get that trademark application on the register as soon as you can, because
that filing date.
Your rights will always be so much stronger by the time you have that registered trademark.
Yeah, and the rights, your registered rights backdate to that filing date. So it's as if you've got the registered mark as of that date when it's finally approved. Get the date, you get the rights as the registered rights as of that date, backdate to when you got the filing date.
Yeah.
The rest is just a matter of formality.
Exactly. Yeah. So there's definitely a rush in a sense, and it also has to do with the overseas trademarking. I briefly mentioned before that there's a difference between some countries having a first to use method and some countries having a first to file method. So also for international trademark registrations, it's really important to make sure that you're the first in some cases. So definitely start this discussion as soon as you can.
We often say this as well, time is of the essence, like you just don't want to be in a situation where, you leave it, you leave it and then, a month later, you realize that someone's registered the trademark beneath you, and then you have to go through this process of opposing them, etc. It's just, just get it done, get it done now, get it on the register. Stitching time says 9 or 90, 900, 9,000, or the whole bag. That's what I keep saying. So get that filing date now. Then you can at least rest easy that anybody that applies after that date, yours should come up as an objection, to theirs.
Yeah, exactly.
All right, myth 7.
Jacob, you want to quickly run through myth 7?
Yeah, sure. So if someone has registered a trademark, no one else can register and or use the same trademark. So it comes back to what we were discussing before about trademarks are in relation to a particular set of goods and services. You apply for it in relation to those goods and services, and you have exclusivity over that. You do have a little bit of protection, a little bit of leeway as to, if there's goods or services that are similar to yours, for instance, protection over shoes versus retail of shoes, that sort of thing. But yeah, ultimately, if you have a trademark for shoes, you can't go after someone who's, maybe a digital marketer or something like that using the same name. You don't have just a general monopoly over the name. It is specifically in relation to what it is that you have claimed.
Because of that, it actually happens quite often that the same trademark will be registered for different sets of goods and services, and there won't even be anything that you can do because there's no risk of confusion. I just mentioned here Dove being used for soap and for chocolates. Now, a reasonable consumer won't look at the Dove at the soap section and then later see Dove in the chocolate section and think that those two products derive from the same trade source. So because of that, because there's no risk of confusion, those marks are perfectly fine to coexist on a trademarks register, and both have their rights given to them, and both being allowed to use those rights, etc. Because it's all about potential risk of confusion.
As long as Dove doesn't start selling chocolate soap.
Exactly. Maybe that already happened. Who knows? Or tried. Yeah. That same goes for international trademarks. So because there's a limitation to a registered trademark only being registered in your jurisdiction, it is possible for someone in a different country to have the same trademark. So because of that, again, it's important to discuss all these things at the beginning of your trademark protection strategy phase. Make sure that we have a proper strategy in place to make sure that we can register a trademark for the goods and services that you require protection for, and in any country that you might need it, because there are limitations to the rights that you are being granted at the end. Well, seeing we only have 1 minute, I should move to the next myth. Myth number 8. IP Australia will inform you of any conflicts. We have actually discussed it already, so it is a yes and no answer, where they do inform you of some conflicts because your trademark will be raised as a citation to new trademark applications or registrations. when your trademark is identical, substantially identical, or deceptively similar to that trademark, and it relates to the same or similar goods and services. Now you hear the limitations there already. And at the end, people work at IP Australia, and sometimes something won't be picked up, or sometimes the other party might be able to overcome the citation based on your trademark because they have used their trademark for so long. It might be several reasons that would have happened there. But when those kind of situations arise, you might need to rely on the opposition stage. So after trademark is accepted, the trademark will be published for 2 months for opposition purposes. And for some of the reasons I just mentioned, it might be necessary for you to file an opposition. So IP Australia would inform you when your trademark is cited against an application and that application is accepted. So then at least you're aware of the fact that that trademark is accepted, the opposition period will start, and you can file an opposition if you want to. But you won't know whether your trademark is holding any trademarks back until that moment. So IP Australia doesn't actively reach out to tell you, hey, your trademark has been cited, that trademark is being held back because of it. It will only tell you when that trademark would be accepted despite the citation based on the trademark.
And if you've got a trademark that's you really wanted to protect, it's great to have we do a watching service for clients. If you're wanting to just make sure that no one's trying to get on the register where yours is being cited, because IP Australia won't tell you if that's the case, as well as other searches we can do.
Yeah.
All right, myth nine.
Myth nine.
We're over time. Myth 9.
I know. Sorry, I'll quickly run through them. If I don't know anyone that's using a similar trademark, I don't need a registered trademark. I think we've basically covered that with a lot of information that we've already mentioned, showing how a trademark is still beneficial. It's not just about enforcing rights. It's about, showing that you have the undeniable rights to a brand. And having that in place is preventing a lot of people from adopting that trademark, and it's holding back a lot of trademark applications. There's so many benefits. I think we would have mentioned them all in the last hour. So it's definitely worth getting that trademark, even if you don't know that there's already an issue in place. Plus, like Ian mentioned a few times, you don't want to deal with that headache. So best to prevent it from happening in the first place. Number 10, unless you guys have something to add for number 9. Number 10, there's no reason you need to hire a trademark lawyer or representative. We get a bit of hesitation sometimes when there is a trademark and we do a direct conflict check, for example, and we're like, yeah, it looks like your trademark is registrable. We would recommend going ahead and filing that application as soon as possible. But then the bell might ring that they think, well, why do we need you in the first place then? Because it sounds like we can do it ourselves. Now, in some situations, it might all turn out well, but we deal with the aftermath a lot of trademark applications that were filed by the trademark owner, and there's just a few inconsistencies in there that were not picked up. The trademark might be filed in the wrong name, listing the wrong owner on the trademark application. It might not cover the correct goods and services because it can be a bit confusing how they're listed, and it needs a bit of retrospective. Like you want to make sure that you cover everything, not just that you're doing now, but also the things that you might be wanting to do quite soon. You might need to take the international perspective into consideration from the beginning. There's quite a few things that can go wrong at the application process that can be, again, a huge headache down the track. And it might resolve in your trademark being eligible to be removed, like we discussed. It might mean that when you need to rely on those trademark rights, they're not there for you. And to prevent that from happening, it's best to get an expert to help you in the application process. The costs of having some professional help you at the beginning are just so much lower than the cost of having to deal with any issues that you might have down the track. And
I've seen so many Facebook posts, right? Seen so many Facebook. Oh, I did it myself and it was easy, and then, we've even had a look at some of those trademarks where some of those people said, oh, I did it myself and it was easy. And we picked up the fact that, it wasn't done properly and wasn't done correctly. And then, we know full well that they may not be enforceable for a start. And secondly, they're operating on the assumption that they've got this they've got this done and they've got this done registered and it's and they're protected, but ultimately they're not protected fully over what they're doing, as well as as well as potentially being filed in wrong legal entities, and not having proper coverage. Anyway, like anything in life, if you do things, anything I've done for the first time, I've usually stuffed it up. Although IP Australia has made this a fairly straightforward process, it seems to change some stuff recently. It might appear to be a straightforward process, but it's one of those things where the poor man pays twice, and often there's a we have to have difficult conversations with clients to say we're going to need to file this again and do it properly, and so save you they've done their dough on their first application. It's not a great look having trademarks on the register that aren't filed properly. So yeah, there's some difficult conversations that we've had with clients where we say we need to file these again because and sometimes the issue is that they can't be cured by any transfer because it wasn't filed in the correct legal entity at the time of the filing, and there's some case law that's been handed down about that, which makes it really which we just don't want to have to get into a fight about. So we have to advise clients, to file again in some circumstances, which isn't great. But like I said, anything that you've business owners much more, their time is well spent on the things that they do well, and getting experts to advise them on specific legal stuff that we do day in, day out. We've filed tens of thousands of these trademarks cumulatively. So that's why having experts is so important. And the more we realize, the more trademark work that we do and oppositions and fights and all the rest, it really does come down, the devil does come down to the detail and making sure that everything is perfect and right from the start. And when it comes time to enforcement, which is what it's all about, then you want to make sure that everything is right and honky-dory, just like you would if you had terms, conditions and legal documents. You want to make sure they're all I's dotted, T's crossed, clear, unambiguous, because you can't put the genie back in the bottle, the toothpaste back in the tube afterwards. That's the real danger.
Yeah.
I know it sounds self-serving, but we see the benefit of this advice for our clients, and our clients obviously the benefit from having experts that do this day in, day out, do it, and also too, they get the associated advice that goes along with it, because sometimes it can be a case of, oh, I couldn't get this registered. Yeah, but if we do this and we do this, we might be able to get you some registered protection, which is what it's all about too, getting some registered protection, and some registered protection is better than none. But again, I go on. We could talk about this for hours. I know we're out of time now. Jacob, any final thoughts or comments as Riet and I were talking?
Yeah, no, so it's pretty much just going back to the fact that, expressing how important trademarks are and how important it is to have the trademark correct from the beginning. That, there's no room for mistakes at the beginning, that, those mistakes could ultimately cost a fair bit.
Because you can't change the application once it's filed to broaden the scope of the trademark. There's only very limited ways you can change a trademark. But obviously you can change it to limit the scope of the goods and services after the trademark is filed, but you can't expand on it. You can't make substantive changes to it. So it's not, once it's kind of set in stone, really, once it's filed, subject to a few exceptions. That's what I forgot to mention. Thanks for prodding me on that too. Riet, any final thoughts?
Just before we would end this CPD, we do have an IP checklist that we've set up for any clients and other related businesses to use. So I've just, we have quickly put some slides in, but you can find them on our website at progressivelegal.com.au, and it's available for anyone to download and to help you figure out what IP you actually hold and how you can best protect that. So I just wanted to mention.
So for lawyers, this is a really we couldn't find this out in the market, an intellectual property checklist for Australian businesses. So we put it together. It took us a year to do this. So hopefully you find some good value in this. And as intellectual property, the oil of the 21st century is starting to a mass in even in small businesses now that IP is becoming very, very important. And we've realized over the years that businesses don't know how much IP they're actually accumulating. It's kind of like moving house. You only really know what stuff you've accumulated over that time until you have to move house. So doing an inventory, a stock take on all the IP in the business owners and lawyers acting for business owners realize quickly how much IP is actually sitting in businesses nowadays. And it can be anything and everything from social media handles, domains, trademarks, whether they're registered or unregistered, copyright in various works, were they done by the organization or external to the organization, and mapping out where they sit, what legal entities stuff gets missed along the way or registered under different names that needs to be transferred and all the rest. So yeah, it's a really useful resource. We're getting some great feedback on it from our business clients, as well as and if you're a lawyer listening to this as well too, feel free to have a look at it and forward to clients. It's there to use. Thanks very much, Jacob and Riet, for your time today. And I've enjoyed the webinar as well. Hopefully everyone that views it has had a good time too. And I know we love talking about this stuff. We nerd out on it. So if you've got any questions about trademarks at all, just give us a buzz. We're happy to help and happy to have an initial chat with you and at least give you some high level advice on what you can and can't and what the prospects might be before we provide you with a quote for the services that we can do. Thanks everyone and have a nice day.
Thanks.
Thanks.